Okay, everyone, I'm just waiting for a few more attendees to join, and then we'll get started. All right, let's get started. So good afternoon, everyone. My name's Adil Mohammed. I'm one of 3 partners, along with Jillian Stovall-Rivers and Andrew Herlick of Surround Wealth Advisors under the Assante banner. I want to thank all of you for joining us for the second of 3 web events entitled What You Need to Know About Joint Assets. We started these webinars as a result of COVID, and we've continued to see strong interest. A couple of items to mention just before we get started. You will all be automatically muted with no video. However, we still encourage questions, which you can submit by clicking the Q&A button at the bottom of your screen and typing your question. There's a second option of clicking the raise hand button at the bottom of your screen. And if time permits at the end of the presentation, I can unmute you so you can ask your question verbally. Keep in mind that any questions that we do not get a chance to answer, we will get the answer for you after the event and follow up. As a reminder, our first webcast was titled 2022 Investment Outlook, and our guest speaker was Jeff Marshall, Senior VP, Senior Portfolio Manager, and Head of Fixed Income at CI Global Asset Management. At Surround, one of our core beliefs is that wealth is more than money. And today we continue our commitment towards trying to educate on topics beyond money and investments and focus on the equally important tax, estate, and legacy planning. Our guest speaker today, Keith Masterman, will be a familiar name to many of you. This will be the 3rd time we've had the pleasure of listening and learning from Keith. We've received tremendous feedback from his previous presentations. The first, which was the 7 deadly sins of estate planning, and the second was titled The Role of the Executor. Keith is able to take, in many cases, technical topics and bring them to life through real-life examples and cases. Today, he will be speaking on another topic that is top of mind for many: what you need to know about joint assets. In the last few months, multiple clients have spoken to us about adding a child or spouse to a property or to an investment account. People more than ever are looking for strategies to reduce tax or probate or understand the most efficient ways to transfer assets. It's important to understand the tax and estate implications of making an account or property joint, not only today, but in the future. Keith Masterman is Vice President of Tax, Retirement, and Estate Planning at CI Global Asset Management. Keith is a lawyer with more than 30 years experience who specializes in estates and trusts and holds the Trust and Estate Practitioner designation. He joined CI Global Asset Management in 2015 after being an executive with one of Canada's major banks, where he predominantly worked in the estate, trust administration, and planning areas. Prior to joining the bank, Keith was in the private practice of law, providing estate planning and administration services and representing parties in estate litigation. With that, Keith, thanks again for being here, and I'll turn it over to you.
Great. Well, thanks very much for having me back. It's always a good sign. It's always a good sign to start with that they've asked you back. So there you go. So that's wonderful. So as Adil said, my presentation today is called "Is It Really Time for a Joint?" Ha ha ha. Planning considerations and joint assets. And I think I chose this topic for a couple of reasons. One of the main reasons is because placing assets into joint name is a really, really common and popular way of minimizing probate fees. And we'll talk about that in a minute. But I also believe it's going to become more and more popular over the next few months or next few years. And I think that for a couple of reasons. One reason is because Ontario started a new estate process last year. And if you can get your estate, the things that actually pass through your will, under $150,000, which is a bit of a challenge, but with joint assets and stuff, you can do it. You can take advantage of a new streamlined process to apply for probate, and your probate document will be ready in 5 days. Currently, probate takes months and months and months and months and months, so that's a huge savings time-wise. So I think people are going to be saying, how can I minimize the value of my estate for that reason? I also think people are going to be minimizing the estate, or should be thinking of minimizing the estate, because of the estate information return. And we'll talk about that during the presentation and exactly what that is and why people are minimizing it for that reason. So I chose it partly because it's a very popular thing, but also I chose the topic because We get a lot of questions about placing assets into joint name, like Adele was talking about, with a child or with an adult. And we get a lot of questions about the ramifications of doing so. And also, as a lawyer, reading my Ontario reports every day that come through about new cases, boy, do I see a lot of fights by people who have put assets in joint name, and now the family's fighting. And I'm sure every one of those families started with the same line: it'll never happen to my family. But you know what? It does. So that's what we're going to talk about today, or at least that's why I picked the topic. So the agenda today is, first we're going to start by looking at a case study. And the case is about Bill and Mary. They are a middle-aged couple, and we'll get to know them a little bit. And we'll also get to know a little bit about their advisor, whose name is Ruth. In coming up with the fact situation for Bill and Mary, I guess I should mention that this is a case, or pretty closely similar to a case that the Law Society of Ontario introduced a couple of years ago to talk about joint assets and some of the negativity of them. We're then going to look at a second case, Tony and Glenda. Tony and Glenda are not a couple. Tony is a father, Glenda is his daughter, and they've also gone to see Ruth, and they've said, we want to put all our assets into joint name with Glenda. And again, I've taken the facts from that from a case called Cook and Cook, and I'll tell you the facts of Cook and Cook when we get there. But it's a very interesting case, and talks a little bit about joint assets from a different angle. After looking at those two cases, we're then going to look at the legal status of joint assets, the different ways joint accounts can be held as joint assets, and some of the ways people can fight over joint assets. So some of the ways that your family, if you put your assets into joint name, might fight after you pass away, and we'll talk a little bit about that. We're then going to look at some non-tax considerations. I like to think of this as bulletproofing yourself, or looking at the things the courts will look at if someone challenges a joint account, and some of the things you might want to think about doing today to prevent or minimize that risk of your family fighting in the future. We're then going to look at the tax considerations and some of the things you should think of from a tax point of view before you put assets into joint name. And then we're just going to do a quick little summation. So that's really what our agenda looks like today. So let's look at Bill and Mary and Ruth, their advisor. So as I said before, Bill and Mary are a middle-aged married couple. Bill, unfortunately, has discovered that he has inoperable cancer. So, works like a dog through his whole life, suddenly goes into retirement, and then finds out he is very, very ill. Having cancer or facing his own mortality is something that's increased his interest in tax-efficient estate planning, so he goes to talk to his advisor. Ruth, his financial advisor, suggests they consider transferring all of Bill's investments and bank accounts into joint name, and also ensuring that Mary is the beneficiary of his RIFs and TFSAs. So that's what they decide to do. And then the question is, well, why did they decide to do that? Well, first of all, is convenience. If assets are in the estate, so when you place assets, when assets pass through your will, they will be trapped in the probate process. And after probate, the banks, etc., have the right to freeze those assets until such time as you apply and obtain probate. And as I said, unless that's one of these small estate things, that can take months and months and months. And the only thing the bank has to release funds for from the bank account, if it's in your name, is for your funeral costs. Everything else can be frozen. And I've seen an awful lot of situations where a family has come to us after the fact and has said, everything was in dad's name, it's all caught in probate, we're applying for probate, it's all part of his estate, but mom needs money, and she needs money for foolish things like food, heat, hydro. How can she get a hold of it? And unfortunately, the truth of the matter is, if the bank chooses to freeze, it will. Well, if it's in joint name, that doesn't happen. It passes automatically to the beneficiary. The second one is estate tax savings, or probate. And this is the number one reason we see people putting assets into joint name. There are two taxes that are come into effect when you pass away. The first one is, and the bigger one, is there will be a deemed disposition of everything you own on date of death. So the night before you die, CRA assumes you sold everything you owned at fair market value. All your registered accounts, 100 cents on the dollar, is added to income in the year you die. Any capital gains on unregistered accounts or any assets with a capital gain, that capital gain is added to income. So you're going to have a huge income inclusion in the year you die. This is if you're passing your assets on to someone other than your spouse, because there's a rollover for a spouse. And so in the year you die, chances are really good you're going to have a big income inclusion in taxes. And remember, the highest marginal tax rate which comes into effect at $210,000 in income or something like that, is 53.53%. So you're going to have a big tax implication. The other tax, though, and the one that can be minimized by putting assets into joint name, is that probate fee. So probate is the cost that the government puts out. It's a tax for issuing what's called a certificate of estate trustee with a will. And as you guys probably know, I'm a big fan of probate. I think people should get probate, and we can talk about that during the question and answer period if you want to, about why I feel so strongly about it. But the more I minimize the assets passing through the estate, the less my probate fees will be. Probate fees in Ontario are 1.5% of all assets that pass through my estate. And so if I had an estate of $2 million, 1.5% of all assets over the first $50,000 in assets. So if I have an estate of $2 million, my probate fees will be $29,250. So it's not an insignificant amount for larger estates. And a lot of people put assets into joint name to end that. The other things I mentioned earlier that's associated with probate is the estate information return. So a few years ago, I think it was 2016, might have been 2017, the Ontario government said we're not receiving enough money in probate fees. And what they decided to do was they decided to start a new process. So within 180 days of obtaining probate, you have to apply for what's called an estate information return. An estate information return does two things. It guarantees that every asset owned by the individual is listed, and it guarantees all values are correct. And so it's sort of a double check, because on probate, all you have to do is use best efforts to determine the valuation of assets. But the estate information return, you have to go out if you're an executor and actually find concrete evidence as to valuation. You're gonna have to get appraisals done, etc. So the upshot is, for assets that pass through the estate because of the estate information return, estate administration got more time consuming, because now you're gonna have to go out and get all these steps. And it also got more expensive because you're going to have to go out and hire appraisers, etc. The government has the right to audit your estate information return. They might not do it, but they can do it if they choose to. And if they do it and they determine your estate information return is inaccurate, the penalty is $1,000 for your executor, plus 2 times any probate fees they feel are avoided, plus up to 2 years in jail for your executor and any professional such as a financial advisor who assisted in the valuation. Now, I mentioned all that as just way of background about estate information returns. The big issue with estate information returns is if the government decides to audit your estate information returns, the legislation says that they may share the results of that audit with any other government department, including CRA. So if your estate information return gets audited, chances are really, really good your tax return is going to get audited too after you pass away. And so a lot of people are saying, well, I want to minimize my estate, my probate, partly because of the probate fees, but partly because I don't want my poor executor to have to go through the estate information return. And any asset that doesn't go through it isn't caught by it. And then the last thing is, probate is a long process. It can take months and months and months, and your estate is going to be tied up. Last March, last year, about a year ago today, the government started that small estate process, saying that if an estate's got less than $150,000 in value, you can do the streamlined probate application process and you'll get your certificate in 5 days. So a lot of people are saying, forget about the fees. I just want to minimize my probate because I want to also take advantage of those other two things. And then the last message is, of course, privacy. You hear this all the time. Anything that goes through your will is public. I can go down to the courthouse and read all your assets and everything else in your probate application. That's not true if assets pass outside because of jointure. No one else will know about them. So that's largely why the couple decided to do the things that their advisor suggested. Well, it's now 6 months later, and things have come to light. Bill has now passed away, and some facts have come to light that Ruth and her advisor did not know. Firstly, Mary is his second wife. Bill was married before, and as part of his divorce decree from Jane, his first wife, Bill has agreed to pay spousal support for Jane's lifetime. Bill also left a will, and in his will, he left $50,000 to each one of his 3 children from his first marriage. And also, lastly, surprisingly enough, Jane did not know that Bill was a bit of a gambler, and he had huge gambling debts that Mary didn't know about. So now they're in a bit of an awkward position. And they're in a bit of an awkward position because by putting everything in joint name, nothing passes through Bill's estate, or very, very little passes through Bill's estate. And we now have a whole bunch of really, really upset parties. The upset parties include the creditors. And if I was advising the creditors, if a creditor came to me and said, we got an estate with absolutely no assets, and so we can't collect our debts, I would be suggesting to them that they look at whether there's whether putting the assets into joint name was a contradiction of the Fraudulent Conveyances Act. In Ontario, if you put assets into joint name or transfer assets at a time when you knew or ought to have known you were avoiding creditors, that transfer is void. And so I think the first issue that the poor executor of the estate is going to have, and that's probably his wife, is that creditors are going to come and say, if you don't pay us, we're going to bring an application and declare and try and declare the transfers fraudulent into joint name, and we're going to therefore seize. The other affected party are the poor children. Each child was left $50,000. Well, they're now likely disinherited, because if everything passes by jointure, everything becomes Mary's asset, and there's nothing for the three children. Now, Mary may well decide, I'm going to give the three children each $50,000, but that's completely up to her, because the assets were in joint name, they become hers. And she might not love her stepchildren as much as the next person. And of course, the third person who's in a difficult position is Jane. The deceased, Bill, was to pay Jane for the remainder of her life, but there's no assets in the estate. So Jane might have a claim against the estate, and she might be able to claim for being a dependent on the estate or for breach of contract. But I suspect she's also going to try and sue Mary. I suspect Mary's the executrix of the estate. And she's going to argue that you as an individual assisted Bill in removing assets from your estate at a time when you were doing it to avoid me. And I suspect Mary might be sued successfully. The other thing is, it puts Mary in a very difficult position. Assume she's the executor of her husband's estate. That's quite often the common situation. She's going to have to negotiate with Bill's ex-wife. It might well be that Mary is the reason Bill has an ex-wife, and it might be that these two women don't love each other quite as much as the next person. But the bottom line is, good advice, putting assets into joint name to avoid probate without looking at the whole situation, caused a whole mess load of problems here. Now, if I was a lawyer and anyone came to talk to me, I'd talk to them about the Fraudulent Conveyances Act, but I'd also talk about attacking these jointures on the basis of the presumptions. And we'll talk about what that means later. I just want to throw the word out right now. So the next client we're going to meet the father and daughter team right now. And this is, the father is named Tony, and Tony has a daughter named Glenda. Glenda is what I like to call his go-to kid. Glenda's the girl who comes and looks after him. She takes him out banking. He finds things overwhelming. And so again, his advisor, which again is Ruth, suggests to them, well, why don't we put assets into joint name? And that way, it'll be easier for Glenda to work with you. Now, why did they suggest that in this particular case? Well, there are three situations. One is convenience, but it's a little different than the convenience in the last one. Here it's the convenience of knowing that his daughter can handle those assets during his life. She can help pay the bills. She can take money out of the account. She can do all those sort of things. She's like a power of attorney without naming a power of attorney. So it's sort of a situation of convenience. Secondly, for tax savings and all those probate reasons we talked about earlier. And thirdly, it's the ease of transfer. When Tony dies, Glenda will automatically receive the money. They won't pass through probate, and the money will be immediately available to pay off his creditors and to plan for his funeral and all those other things. So it's just a matter of convenience. And those are a lot of good reasons to put assets into joint name. Well, it's 6 months later. Tony has now passed away. Looks like all my fact situations, everyone only has 6 months to live. I don't know, that's a bit of a coincidence, but anyway, but not everything is as it should be. Tony has left an estate where he divides his estate equally between his three children. Glenda wasn't his only child, he had two other kids. And his other daughter and his son vehemently say that the funds that are in joint name were meant for all three of them. Glenda, on the other hand, is saying, hey, wait a minute, Dad put it into joint name. I'm the beneficiary of these estates through through the right of survivorship, and I'm going to keep the money. I think Dad did this to thank me for all the help I've given him the last couple of years. Now, I told you before that this is loosely based on a case called Cook and Cook. And I'm going to talk to you a little bit about the situation in Cook and Cook, just so you can see the type of situations that make these families blow up. In Cook and Cook, we had an elderly man, Mr. Cook, and he had 5 children. And just like the situation here, he decided to put his assets in a joint name with his oldest child. He didn't have that many assets. He had an investment account with $80,000 in it. And then he had a bank account with about $6,000 in it. So we only had $86,000. He put his assets in a joint name with his oldest daughter, and then he passed away. After he passed away, his daughter had her brothers and sisters come to her house, because she said, you know what, I think it's important you know what Dad did and what Dad had. So she said Dad had about $86,000, $80,000 in an investment account, $6,000 in his bank account. The investment account he put in joint name with me. And I know that he meant me to have that as a thank you for everything I've done for him. So I'm keeping the $80,000. You're not getting a nickel of it. She then said, and you know that $6,000 that's in the bank account? It's not in joint name. It's solely in Dad's name. But you know what? I'm his executrix, and I'm taking that as my executor fees. So you guys are going to get 0, and I'm going to get the entire $86,000. Thanks for coming over today. Hope you enjoy the coffee and cookies, was basically the message she gave him. The kids were furious, and her brothers and sisters sued her, and they sued the estate, and they sued at trial, and they sued at the Court of Appeal. And their argument was, and we'll get into their argument in a minute, but their argument was basically, Dad didn't do this to benefit you. He didn't love you better than me, and he certainly didn't love you $86,000 better than me. He really meant this for everyone. And I don't care if it was in joint name or not, we're suing to get our paws on it. Now, think about this for a minute. The probate savings of $86,000, remember probate is 1.5% of the value of the estate over $50,000. So the probate fee savings was $540. That's all the probate. And they spent 3 days in trial and 4 days in the Court of Appeal arguing about this. They had 5 kids in an estate, all of whom had separate lawyers. How much of that $86,000 do you think was left at the end of a Court of Appeal battle? I'll bet you any money it really, really was a lot higher legal fees than the $540 they saved. The end of the result was that the daughter won. She got everything and her brothers and sisters didn't. I can't guarantee what's happened since with that family, but I'll bet you they don't get together for Christmas dinner anymore. I seriously doubt they all went, well, let's bygones be bygones. Let's get together for that summer picnic. And my number one rule about estate planning is my job is to make sure your family can still have dinner together. And here's a case where I think putting assets in joint names to save a very small amount of money was a terrible, terrible move. Okay, so we've talked a little bit about our 2 fact situations and how you can see a lot of bad feeling and a lot of things go wrong. So let's talk a little bit about the law and exactly what the situation is from a legal point of view. So I'm going to put my legal hat on and talk a little bit about joint assets. So in Ontario, there are 2 ways of holding property in joint name. There's tenancy in common, and then there's joint tenancy. Tenancy in common is when 2 or more people own property together, where there's no right of survivorship, each has a defined ownership interest in the property, and you can sell or gift or transfer whatever you want to do to your interest in the property. So by way of an example, let's say my wife and I and my brother and his wife find a great investment property and we decide to buy it together. We'll probably want to be in tenants in common, because if anything should happen to my brother, he doesn't particularly want my wife and I to receive his interest in the property. He wants it to go to his wife. So we can be tenants in common, and we can say, my brother put up more of the money, he can own 70% of the property or 80% or whatever we decide, and Chris and I, that's my wife, can own the other percentage. I can sell my interest, I can give it away, I can will it in my will, it's mine. I can do whatever I want with it. And the remainder remains with my brother, and he can do all the same things with his property. So that's one way. And tenancy in common largely is for corporations, or shouldn't say that, for business interests. People are saying, I'm not quite as closely related as a husband and wife situation. I want to put it in tenancy in common. We're not going to talk much about those. The other one is joint tenancy, and this is the one where people are using it for probate purposes. And that's where two or more people own property, but each has a 100% interest in the entire property. You can't have a percentage in joint tenancy. So if my wife and I own our property I'm talking about from right now, we each have an undisputed interest in the entire property. We're joint tenants. If I die, I can't leave my interest to anyone else. It automatically becomes my wife because we are one unit who own this property. So if my will says I want to leave my interest in this house to my wife, to my children or my grandchildren, can't do it. It automatically goes to Chris. So joint tenancy is usually situations of spouses or where you have one child or two children and you want them to receive the money. It's sort of close family situations. If I was on a second marriage, I might want to hold my property as tenancy in common because I might have different heirs than my wife does. But those are the two types of joint properties in Ontario. What we're going to talk about from now on is joint tenancies. Well, the law of joint tenancy became a lot more complicated in around 2007 because the Supreme Court of Canada heard the Picard decision. And I'm going to tell you the facts of Picard quite quickly. What happened in Picard was this. There was a gentleman named Mr. Hughes. Mr. Hughes had 3 daughters, but fortunately for our purposes, because it makes it a lot simpler, he seemed to only like one of them because he wrote a will and he left his entire estate equally to his daughter Paula and her husband. So he said, when I die, 50% of my estate goes to Paula and 50% goes to Paula's husband, Michael. He then went in to see his financial advisor. And he said, what I want to do is I want to put my investment account, which had $950,000 in it, in joint name with Paula. That way, when I die, it's one of those joint tenancies, it automatically passes to Paula and bypasses probate. So that's what happened. Well, Mr. Hughes died and the money was inherited by Paula and Michael. Whether Paula and Michael received it because it was in joint name and it all went to Paula, or whether it went through the will and Paula got half of it and Michael got half of it, who cares? It all ended up in Paula and Michael's house. It all ended up in that one pot. And so they lived happily ever after for about 3 years. After 3 years, Michael and Paula got a divorce. And suddenly people cared a lot about how Michael and Paula got that money. Because you see, in Ontario, if you receive a gift after you get married, that gift doesn't have to be divided in a divorce. So if Paula received the money because it was in joint name, that's a gift. And Paula would be able to receive, keep all $950,000 and Michael would get nothing. But if the money went through the will, Michael inherited 50% of it. So he'd get $450,000. So Michael sued. He sued at trial, he sued at Court of Appeal, then he went to the Supreme Court of Canada. And his argument was, old Mr. Hughes didn't put this in joint name because he didn't really expect Paula to get it. I don't know why he put it in joint name, but it really goes through her will and I get half of it. And the court looked at it and they said, you know what? We think there are 2 types of joint accounts in Ontario or in Canada. One is your joint account with right of survivorship. And a joint account with right of survivorship, we're going to build a presumption. And we're going to say that if you put assets in a joint name with your spouse, the law presumes that you really meant that as a gift and it's a traditional joint account we just talked about. But if you put in an account in joint name with anyone else, your daughter, your son, your grandchild, who cares, anyone else at all, the law presumes that what really you intended was the person who receives it is holding it in trust and has to be returned to your estate and divided up in accordance with your will. Both of those are only presumptions. You can leave whatever evidence you want to try and rebut that presumption, but that's the starting point for the courts. And so sort of putting it into stripping out the legalese a bit, if I transfer an asset for value, so if I put assets into joint name with my son, and I say to him, I want you to give me some money because I'm going to put this in joint account, it's a gift. There's no presumptions at all. If I transfer assets into joint name with my wife, the law presumes that I meant it as a gift. That's a presumption. It can be rebutted by evidence, but it's presumed that I meant it as a gift and it's a true joint account. But if I put the assets into joint name with anyone else, like Mr. Hughes did with Paula, The presumption is that Paul is just holding it and it's returned to his estate and is divided up in accordance with his estate. So now we have two different types of joint accounts, depending on which of the dark boxes you put it in. The law got a little more complicated in 2014, because in 2014, the Ontario Court of Appeal heard the case of Sowden. Mr. Sowden had $980,000. And what Mr. Sowden did was he went to his financial advisor and he said, I want to put my $980,000 into joint name with my oldest two boys. Mr. Sowden had 5 children. And so they did whatever magic financial advisors do, and the money was put into joint name with the oldest 2 boys. Mr. Sowden left a will that left 0 to any one of his children. None of his children got a nickel. It all went to the Watchtower Society because he was a Salvationist, a member of the Salvation Army. After he died, the 2 boys said, we know the presumption is a resulting trust and it actually goes back to his estate. But you know what? We think there's lots of evidence to rebut that presumption, so we're just going to keep the $980,000. The Salvation Army said, no. He put it in joint name. The presumption is it goes through his will. We want the $980,000. And the other 3 children went, what? Dad loved us. It's not like we were disinherited. And now whatever one of these presumptions you use, we get nothing. And the Ontario court said, wait a minute, there's a third option. And that third option is the court can say, just looking at the situation, we're going to say that the money is being held in trust for someone else. That by putting it in joint name, you were actually saying, I'm creating a trust. You didn't know you were, but I'm creating a trust and I'm holding these assets for someone else. And then suddenly said, you 2 oldest boys, we think your father really meant that you're holding it in trust for the 5 children. We're not going to give it to the Salvation Army. We're not going to give it to just the 2 of you. We're just going to give it to all 5. So there's an awful lot of uncertainty with joint accounts because who knows which one you intended? And that's where all the problems arise. So how does the court decide what type of joint account you have? If someone sues, so let's go back to the situation of Mary and whatever his name was, the gentleman who died of cancer. Remember, he had those 3 children who were upset, and they're going to attack those joint accounts and say, we know you put it in joint name with your wife. We know the presumption is that you really intended her to have it, but we're going to fight you. What evidence will the court look at? Or another way of putting this is, what things should you put in place today to make sure that if there is a fight in the future, your views will be kept? Well, fortunately for us, Mr. Justice Rothstein, who heard the Bakor case, gave us a list at the back of Bakor and said, this is what the courts are going to look at. And that's what these next few slides are. The first thing Mr. Justice Rothstein said is your financial advisor who helped you must always be a witness at one of these trials. Must. Because the financial advisor is the only neutral party who met with you. They're the only party who can tell what information was conveyed to you. And they're also the only party who can give me any evidence about the state of your mind and whether there was undue influence. So I must see the advisor and I must see their notes and records. The advisor in the Bakor case, I've met several times. He was on the stand for about 4 or 5 days. So it can be a very long process to get their full testimony and to read all their notes and records. But the first thing the court says is we must see their notes and records. Well, that's not the only thing the court looks at, obviously. They look at a whole bunch of other things. Mr. Justice Rothstein said, we also look at the use of the property. We look at things like who contributed to the property. If an asset was put in a joint name, let's say I put an asset in joint name with my son, a bank account or an investment account, who took money out of that account? Who withdrew funds? Was my son able to? Or was I the only one who did? Who contributed funds? Did my son contribute funds or was it just me? Who met with the financial advisor? Was it just me? Or suddenly did my son start meeting with that financial advisor? That's pretty strong evidence that it really was a gift if they were the ones who met with them. Who got statements? That's a biggie. Did the financial advisor start sending only me statements because it's my money? Or did they start sending statements to both myself and the new joint owner? And that's a big one. The court say if you're sending statements to everyone, that's pretty good evidence that you really intended this to be a gift. Secondly, taxes. Who paid the taxes associated with the property? So if there's future gains on those accounts, did I pay 100% of the taxes or did we divide them up and pay part of it for each of us? When assets are put in a joint name, is the second point under taxes, there's a deemed disposition. So if I put my investment account and it's had financial gains of, it's got capital gains of $100,000, and I put it into joint name, the government says, or CRA says, Keith, 50% of that gain, when you put it into joint name with your son, we're saying you realize that. So someone's got to claim that on their tax returns. Am I the one who claimed that on my tax returns? If I am, that's really good evidence that it was indeed a joint asset because I'm giving up something. If I said I'm not going to count it on my bank accounts at all, then that's really good evidence that it was being held in trust because it's still my asset. So the courts have said, did you claim that gain at that point or not? Your estate plan. Does putting joint name to defeat your estate plan? If it did, then that's pretty good evidence that you didn't intend it to be a true joint account and you held it in trust. Because the court will always assume that you're trying to keep your will plan in place. So there was a case called Morotz about a year ago. And Morotz was an interesting case because what happened in that case was a mother put her house into joint name with her only living daughter, Helen. The house was worth about $476,000. Oh, for the old days when houses were worth $476,000. The mother, in her will, left almost the entire estate to Helen, her daughter. However, she also left $70,000 to her two grandchildren. She'd had a son who died, and these were his children. So she left $70,000 to each of them. Unfortunately, by putting the house into joint name with Helen and bypassing the estate, what it left was an estate with a value of $3,200. So there wasn't enough for those grandchildren's shares. Well, the court said, clearly this is evidence that that money is being held in trust, and it really is part of the estate because nobody wants to defeat their estate plan. So we're going to say it still passes to the estate and the kids get their share of it. Here's some other factors the courts look at. I'm not going to go through them all, but I am going to point out, where is the one I wanted to point out? I'm sure it's here somewhere. There should be something here. Discussions. Well, one of them should be, and I'm pretty sure it's there, documentation of intention. Did you have some sort of documentation of intention? There it is, the second last one. And this is the order which the court set out in PCOR. Quite often this is seen as the most important one, and it's important. But did you set out a document stating what you meant? Was this meant as a true joint account, or was it meant as a joint account for convenience purposes, or whatever you want to call it, by trust purposes? That's tremendously important. A lot of people are putting right in their will or their power of attorney for clarification purposes. Any accounts I hold in joint name are joint accounts with right of survivorship, or any accounts I'm holding in joint name are joint accounts on a trust basis. But it doesn't have to be in your will and power of attorney. But it's tremendously important that you set out the type of documentation, set out your intention and documentation. What you won't see in any of the courts records or list of what they're looking at is you won't see the wording of the actual account form. When you went in and put the asset in joint name, I'll bet you checked something off that said this is this type of joint account or that type of joint account, a whole bunch of things. But the courts have said, we don't really care what the actual form says because we don't think you necessarily knew what it meant. So we're going to really discount what the form said and really, really try and look at this other evidence that the court has set up. So looking at that, I guess the last part I'll say about that is when you start thinking about putting assets into joint name, start thinking about things that you can do to try and minimize. Have a conversation with your family. Make sure that you administer that account in the right way. If it was really a joint account with right of survivorship, maybe statements get sent to both of you. If it's not, make sure that you set it up that way so that the courts are clear about what they're looking at, because it will minimize the chance of fighting. What I want to do now is just look at some non-tax considerations that you might want to think about before you put assets into joint name. And so here are a couple. And I really think that these come down to there's a high risk of litigation and a high risk of families breaking up. So I think it's really important to KYF, know your family. Make sure you understand what your family has to go through. But here's a couple things you might want to think about if you put assets into joint name. 2, you lose control. If assets are no longer in your sole name, you lose some control of the asset. So for instance, if it's real estate, you can no longer rent it, mortgage it, transfer it without the co-owner's permission. And so think carefully about, do you want to lose that control? Where I see control issues an awful lot, and I won't spend much time on it, is the family cottage. I often see that one generation says, you know what, we're going to put this into joint name with our children. And that's a great thing to do at the start. But let's fast forward 12 years. I've put my cottage into joint name with my son and my daughter. 12 years from now, my daughter has a new husband or my son has a new wife. And suddenly they're saying, you know what, I'm getting a little tired of your father always calling all the shots at the cottage. This is also your cottage. I've lost some control over the cottage because it's in both people's names. And that's an unintended effect of it. The other thing about putting property, real estate into joint name, think carefully about your children's position. Did you know that if I put an asset into joint name with my son or daughter and they don't own property, they've lost the ability to qualify for the first-time home buyers program? So all of those warranties and all that thing under the first-time home buyers plan, I've robbed my child of that opportunity by putting an asset into joint name with them. Family law issues. A gift is not included in the division of property. Sorry, a gift made after you are married is not included in joint property for divorce purposes. So if I put my assets into joint name with my son and he's married, that asset is not included in the jointure. However, suppose that it was real property I put in joint name with my son. That might be a matrimonial home. Couples can have more than one matrimonial home. Matrimonial home is just simply where you ordinarily resided. And you can have 3, 4, 5 different places for matrimonial property purposes that are matrimonial homes. So I put that cottage into joint name with my son. That cottage might be one of their matrimonial homes because they used to go enjoy it for some time in the summer. If that's the case, on divorce, if it's in joint name, my ex-daughter-in-law has an equal right to possession of that matrimonial home, and that can cause a tremendous problem. There's ways around it, but I'll just raise the concern. Creditors. I think all of you know this already, but if I put assets into joint name with my son, my daughter, whoever it is, those are subject to their creditor claims. So if my son runs up tremendous debts or is in a terrible car accident and he owes some money over the insurance limits, that asset can be seized to satisfy those debts. A minute ago, I told you that if an asset is put into joint name after my son's date of marriage, it's a gift. It doesn't have to be included in their family law dispute when they separate. However, she will be a creditor. She'll be awarded some money from my son's estate, and my asset might be sold to satisfy her as a creditor. A couple of other things to think about before you put assets into joint name. How well do you know your child or whoever it is you're putting your asset into joint name with? Because there's potential of misuse of transferred assets. I'll tell you a true story that happened to one of my friends. She had a client, and the client put her assets into joint name with her son. The woman had worked very, very hard, and she'd done very, very well her entire life. And she was enjoying her retirement at one of these retirement living places with, outings and wonderful meals and the whole bit. Cost a fair amount of money. Unfortunately, she put all her assets into joint name with her son, who had a gambling addiction. And before you knew it, her entire life savings was completely destroyed. That woman, of course, couldn't maintain her rental on that fancy retirement residence she was living in, and so she's now in a provincial facility, which is an awful lot worse for her, simply because she didn't think ahead about how well do I know this person, what do I know about them. And the last thing is transferring the estate plan. Always read your will before you put assets into joint name. Think carefully about what your will says. Many, many years ago, when I was young and charming, I got involved with this family. And what had happened was this woman had gone into the bank, and the bank had said, if you put your assets into joint name with your son, you'll avoid probate. So that's exactly what they did. Then the woman passed away. Well, after she passed away, we read her will. She had 2 children. She left half of her estate to the son, everything was in his name, and half of it to his sister. Well, that was absolutely no problem. The son said, you know what? I love my sister very, very, very much. And so obviously I'm going to divide the estate between the two of us, and I'm going to give her half of the estate. That's what mom intended, and I'm a good kid. Well, the problem is this. The daughter had disabilities. She was on ODSP, and so there was a special trust set up for her in the will. And because the money would go through the son's hands because he owned it, and then he populated the money into the trust, it didn't count as a testamentary trust, which meant from a tax position, it was in an awkward tax position. Because you see, and without going into too much detail, if you set up a trust in your will for a disabled Canadian, it can be what's called a qualified disability trust, but it has to be in your will. And because this went through his hands, it wasn't a qualified disability trust, which meant every nickel in income generated by that trust is taxed at the highest marginal tax rate, which is 53.53%. So again, think very carefully about your estate plan. Does this mirror what you want to do in your estate plan? And have you really thought of the repercussions? And finally, before I say goodbye to you, just a couple of notes about taxes. So we already talked a little bit about the non-tax ramifications you should think about, but there's also obviously a tax implication. First off, if you're going to transfer assets into joint name and it's a true joint account, so it's a joint account with right of survivorship, CRA says that you've disposed of half of the account at fair market value. So if there's a capital gain, you're going to have to include that capital gain on your tax return in the year you've made the disposition. I don't know about you, it could just be me. I've never quite fully understood why I want to create a tax in my hand now and pay a tax liability now to avoid a tax after I die. I think I'm a little more selfish than that. So I have to really be careful about what that deemed disposition will be. Now, sometimes it won't matter because it's largely in cash or there isn't much of a capital gain. If it's that other type of joint account, the joint account is a resulting trust, there is no deemed disposition because you're not really giving up anything. You're simply putting the person on as a joint holder without right of successor. So there is no deemed disposition. However, if your estate is audited after you die, and CRA is auditing these all the time, and they determine that what your intention really was that it was a joint account with right of survivorship, and you really should have done that deemed disposition, they will audit your accounts, reassess you, and they will apply interest and penalties. So you have to be a little bit careful about that. That was my second point. Attribution may come into play. If you put assets into joint name with your spouse, so if I put assets into joint name with my wife, the attribution rules say that the tax liability for those in the future is still mine, it's not Chris's, for capital and income. And then the other points we have there is if the transferee is a non-resident or citizen of another country, think twice and get some good advice from a tax point of view about the tax implications from that other country's position. And if the property is a principal residence, you might have really messed up your planning, for lack of a better word, by putting it in joint name. What I mean by that is this. Suppose that Chris and I put the house we have right here into joint name with, again, our son, Jack. Jack already has a house, he and his wife. If I put it into joint name with him, half of it is still my principal residence. But Canadians, for tax purposes, can only have one principal residence. A couple can only have one principal residence. So half of my house, by putting it in joint name, is no longer a principal residence because Jack already has one. So the tax liability, which would have been fully sheltered if I left it in my own name, because it could all have been my principal residence, half of it will now be incurred from the date of the transfer. And this chart, which you can ignore or look at depending on how interested you are, is just a summary of the tax implications of putting it into a joint account with right of survivorship, or that resulting trust joint account that we talked about. So it just sort of says, what's the tax on the date of transfer? What happens during your lifetime about who pays those taxes? And what's the tax on the date of death of the transferee? And what's the implication on probate fees? And that, on a conclusion basis, is really all I came to talk to you about. Sort of a conclusion, I think, really, know your family. Look at the downsides that can happen from a joint account, We talked about the lack of control, the family law issues, the tax implications, and also know your family. How likely is it they're going to fight in future about this? Always look at your estate plan, and please document your intention. It'll save fighting and litigation costs in the future. And with that, I will turn it back to Adele.
Beautiful. Thanks, Keith. That was extremely informative, and something that you would think is, I mean, in some cases, very small. Just adding a name can have real significant implications. So, we have a couple minutes. I'm just checking the time here. Yeah, we have a few minutes, and we did receive 2 or 3 good questions. Some of them you touched on, but it might be worthwhile to just reiterate. One of them you actually brought up right at the start of your presentation. You talk about, reasons to try to, reduce probate, the length of time it takes. You got to do the estate information return, all of those different pieces. But then you also mentioned that it's worthwhile going through probate. Yeah. So maybe you could touch on, is it just a balancing act of trying to get things down to a certain level that it's efficient, but you still want to go through probate? So the question is, why do we want to actually go through probate?
Yeah, I think most people don't see any value in probate whatsoever, because from your point of view, what you see is that you fill in a whole whackload of forms, or your executor fills in a whole whackload of forms. You send them down to the courthouse, months and months and months seem to go by, and then suddenly you get this one piece of paper that says estate trustee with a will, and it's got a big seal on it. And congratulations, you spent $30,000 in probate fees for that and some lawyer costs. And you're kind of going, why did I do this? What is the point? Probate does an awful lot of things. First of all, probate is not mandatory. If you can convince every fund company, every bank, everyone in the whole world to waive probate, with the exception of a house, and we can talk about that if you want, likely you need probate to transfer a house. But if you can convince everyone to waive probate, you don't have to get probate. The reason I think it's a good idea is this. I see probate as an insurance policy to protect someone I love very much. My executor is my son, Jack, and I love him very, very much. Probate protects Jack. So it's a 1.5% fee to protect him. And here's the issue. If Jack administers my estate without getting probate, so he phones Assante and he phones everyone else in the world, and they all say, yeah, we'll waive probate fees. And it happens. I mean, I sit on the probate committee to waive probate fees, so I know it happens. But if everyone waives probate fees and Jack administers the estate, and later it's found out there's another will, or someone fights, someone fights the, says that I didn't have capacity, or someone makes a claim against the estate, Jack becomes what's called executor de son tort. And that's just a fancy way of saying Jack has to administer my estate because he started, he's a fiduciary. However, he can be fully liable for any errors he makes. He can never, ever receive a fee, and he can never, ever be reimbursed for any expenses. If he gets probate, he's protected. He can take a fee, he can be reimbursed for expenses. So I don't want him to become an executor de son tort. The other issue, of course, is in Ontario, we have a 2-year limitation period to start suing most people under an estate. So people have 2 years. There's a different limitation period too, but let's simplify this, a 2-year limitation period to sue. That 2-year limitation period starts when you know or ought to have known you have a claim against the estate. But what's that mean? When did I know or ought to know I had a claim? Well, the courts have said it's the date of probate. If you apply for probate, that starts the limitation periods. So I want my son to go to bed some night saying, no one can sue me, 2 years have gone by, I got probate, it's over. Rather than to find someone who says, it's 10 years later, they're suing in the court saying, yeah, you know what, we're going to allow it because we think the limitation period hasn't started. Now, if I have a really big estate, the probate fees is a lot of money just for those 2 protections. So I do want to limit my estate as much as possible through joint accounts where it makes sense, and through other tools like beneficiary designations. But I don't mind getting probate because it's benefiting someone I love. That's a long-winded answer for a very short question. Sorry.
That's actually fantastic, because I think there's a perception or assumption that you want to bring it down to 0, right? Find all the ways to get out of probate, when in reality, you've hit the mark where it makes sense, where it's efficient, but there's value to going through the process. So maybe I'll just go with one more. And the the question you sort of touched on this, but you went through, if you get into the courts, they speak to the advisor, they look at the advisor's records. So what is your advice if a client is looking to put accounts in joint, where you said the presumption is a trust? Now, let's say it should be a gift. What evidence? We don't want to go to court, for example. Nobody does, but what can you do now, or the client do, or the advisor do, in terms of documenting so that you don't get down that path?
I guess there's two things. One, from an advisor's perspective, I'm not going to get into it too deeply, but STEP about a year ago came out with what should an advisor's notes look like in a joint account. And it's very and what they're saying to advisors is, one, make sure it's very thorough, but make sure it's very neutral. You're not giving your opinion. You're saying this is exactly what happened, because it's like, and you're way too young, Adele, the old Dragnet's Just the Facts, ma'am series sort of comes out to haunt me, and I'm sure you have no idea what that is.
No idea.
Yeah, there you go. But it was always Just the Facts, ma'am. From the client's point of view, I think there's two things you can really do to protect yourself. One is, I think you can leave some documentary evidence. The best place to do that is in your will or your power of attorney. Set out for clarification purposes, any accounts I hold in joint name are this type of joint account, and here's the reasons for it. If you don't want to do that, because that can get kind of expensive, you have to go to a lawyer to redo your will, do it in a letter. Do it some way and just leave it with your will. The courts take tremendous consideration of what you say, because this is, after all, your estate plan. So that's one thing you might want to end up doing. And the second thing I think people can do right now is talk to their families. There's nothing worse than having 3 kids come to you and saying, why did Dad do this? I don't understand. Tell them now. They might disagree with you, but there's a lot better chance they're not going to sue each other in the future if they know why you're doing something now. So set it out sort of in a letter form and leave it with your executor or with your will. But also, if you can, if you feel comfortable, have that conversation with your family now, so they understand why you did it.
Perfect. That's fantastic, Keith. So I'll stop there. Again, really, really important information. A lot that we can take back, a lot that we will have conversation with our clients about for anybody who is in joint name, to make sure things are set up correctly. So again, thanks, Keith. I want to thank all of the audience. Appreciate you guys taking the time. I hope you guys found it and everyone found it useful. Then that's it for web event number 2. You will receive a follow-up email. We did record this, so we will send you the link. Any other presentations from Keith, 7 Deadly Sins, Role of the Executor, we have recorded all of these, or any of our web events, so we can send that to you. And our final presentation is set for, the third one is tentatively set for June 8th. We will follow up in terms of the topic and more information. And with that, the sun is shining, so let's get out and enjoy it. Thanks again, everybody. Take care.
Thank you, Keith. Thanks, everybody.
Thanks, everyone. Bye-bye.